Well, hello, dragons, and welcome to this instructional video for Lesson 11, Part 2, the organization of the federal courts. The main idea behind this civics lesson is the judicial branch of the federal government interprets the Constitution and decides if federal laws protect the rights of citizens. With that in mind, by the end of watching this video, you'll be able to describe the relationship between district courts and courts of appeals, explain the role of the Supreme Court, recognize the roles of special federal courts, and summarize the responsibility of federal judges. Now that those outcomes for this lesson have been shared with you, let's get started. The Constitution creates the framework for the federal court system in Article 3. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. As you can tell, the Constitution did not spell out how the inferior or lower courts would be set up. One of the first acts passed by the first Congress in 1789 was the Judiciary Act, which created the district courts and courts of appeals. Although many of the details of the Judiciary Act have since been changed, the federal court system it created is much the same more than 200 years later. The workhorses of the federal court system are the 94 district courts scattered across the United States. Each state has at least one district court, and some larger states have as many as 4. The number of judges in one district court ranges from 1 to 28, depending on the size of the district and its workload. As courts of original jurisdiction, the district courts are the first to hear cases, such as those involving kidnapping or a city's failure to obey federal air pollution standards. Like state trial courts, witnesses are called, a jury normally decides the facts in the case, and one judge directs the proceedings and applies the law. At the next highest level of the federal court system are the 12 United States Courts of Appeals, which handle appeals from the federal district courts. Each court of appeals takes cases from a group of district courts within a particular geographic area called a circuit. In fact, the courts of appeals are often called circuit courts. A 13th Court of Appeals has appellate jurisdiction over cases appealed from certain special federal courts and agencies of the executive branch. It is called the Court of Appeals for the Federal Circuit. A court of appeals has no jury, calls no witnesses, and does not examine any evidence. Instead, lawyers for the defendant and the plaintiff for prosecution make arguments in front of a panel of 3 judges. The judges decide either to affirm the lower court's decision or to reverse it. Like state appeals courts, the courts of appeals are not concerned with guilt or innocence, only with whether the original trial was fair and whether the law was interpreted correctly. The Supreme Court is the highest court in the federal court system. The major purpose of the Supreme Court is to serve as the final court of appeals for both the state and federal court system. The Supreme Court, however, does have original jurisdiction over a few special kinds of cases, including those involving representatives of foreign governments and disputes between state governments. The role of the Supreme Court in the legal system and in the federal government is so important that it will be discussed again in the next video. In addition to the 3 levels of the judicial branch, Congress has also created additional federal courts. These special courts include the Court of Claims, the Court of Customs and Patent Appeals, and the Tax Court. Each of these courts was established by Congress for a specific purpose. Appeals from some of these courts are sent directly to the Supreme Court. Others must first pass through a Court of Appeals or a higher special court. Just as members of Congress do the work of the legislative branch, federal judges do the work of the judicial branch. A judge's role in government, however, is very different from that of a legislator. A legislator is open to the influence of citizens, interest groups, other legislators, and the president. A judge, in contrast, must be impartial, favoring neither one party nor the other. A legislator seeks to solve broad problems by making laws, whereas a judge can only settle individual cases. By applying the law to specific cases, however, judges help define and clarify the work of legislators. In part because judges' jobs are different from those of legislators, judges are selected in a very different way. All federal judges in the district courts, courts of appeals, and Supreme Court are appointed by the President and confirmed by the Senate. They serve life terms and can be removed from office only by the impeachment process. Federal judges shoulder great responsibility. They must balance the rights of individuals with the interests of the nation as a whole. Often they are forced to make decisions which seem fair to one side but unfair to the other. Of all federal judges, the 9 Supreme Court justices have the most responsibility. From time to time, the entire nation waits in anticipation for them to make a decision. Although they are only deciding a specific case, perhaps involving just 1 or 2 people, their decision may have very important consequences for the nation. So that's the way it is with Lesson 11, Part 2, the organization of the federal courts. At this point, you should know that there are 3 basic levels of the federal courts: district courts, circuit courts, and the Supreme Court. Other federal courts serve specific purposes, and federal judges have lifetime appointments in order for them to remain impartial when interpreting the laws. Don't forget to subscribe to my channel to have the entire catalog of civics videos available at your fingertips. Click the subscribe button and then click the follow bell to receive notifications as to when the channel is updated. Thanks for watching, and I'll catch you in class, Dragons.